The following information, material, and content is covered under fair use. This is for commenting, teaching, and training purposes only. Again, this is for commenting, teaching, and training purposes only. This is not to be construed as financial advice, tax advice, nor legal advice. If you need any applicable advice, please seek a licensed professional. Do your own due diligence, regardless of who presents the information. All rights, titles, and actions or interests reserved ab initio without prejudice. And today we'll be reading out of Weiss Concise Trustee Handbook, a guide to the administration of an express trust under the common law, functioning under the general law merchant, by Carlton Albert Weiss. This is the 2008 edition. Something to consider, especially if you have your name on any deeds or any properties or anything really in your name, and it's not being held by some sort of entity. And let's just say that it, for example, even if it's held in a living trust, the thing to be aware of is that revocable trusts are not recognized in every jurisdiction. Meaning irrevocable trusts, one where the settlor loses control of the property and grants that control of said property to the trust that is actually purchasing the property. You have to hold it in some type of express irrevocable trust, meaning that it's entirely separate from the grantor and the terms of the trust cannot be amended. So, there's a difference between those two different types of trusts. That's something to be aware of and something to take into consideration when you're doing your estate planning and considering how you're going to actually be operating your business. So there are some very key differences and clear benefits why you would want to form an express trust rather than a corporation. So these things are pretty well detailed in this Weiss Concise Trustee Handbook. So it says an express trust is governed under equity. Trust law is the most well-settled body of law in America versus a corporation, which is governed by statute. These are forever changing according to political agendas and schemes. Express trusts. Trustees are the sole authority, except where delegated to agents or a board of directors. And a corporation, a board of directors, are managers with limited defined powers to conduct business, hold regular meetings, etc. An express trust, trustees are afforded more leverage and powers are generally broader than corporate officers. Law provides that whatever an individual may lawfully do, the trust can do. The sky, or the nature, is the limit. As a corporation, it has relatively broad powers, such as withholding companies, but corporation may not do whatever any individual may lawfully do. They can only do what is legal. The statute, or the legislature, is the limit. With an express trust, the trustee's liability is limited by trust instrument and by signature on all contracts and instruments. Remember Boyd and Silverthorne, trustees not subject to subpoena. Whereas a corporation, corporate officers are personally liable to legislature and to creditors for all ambiguous endorsements. Remember Enron and Global Crossing cannot escape service of process. An express trust, the lifespan of 20 to 25 years at a time in order to avoid rules against perpetuities. Death of settlor or trustee has no effect on life or the affairs of trust. Succession of power is quiet and private. Whereas a corporation, its lifespan is perpetual for a certain number of years according to legislative requirements. All officer changes must be reported, which records are open for public review. An express trust is not required to obtain a business license, whereas a corporation, the opposite is the case. An express trust, its trustees are not required to file reports with any entity and are accountable only to the beneficiary, governed strictly under principles of equity, whereas a corporation is required to file statements and reports quarterly, etc. And I will add to this, not to mention the fact that now the Financial Crimes Enforcement Network, through the U.S. Department of the Treasury, also known as FinCEN, is creating and has created a registry of all beneficial ownership of LLCs, corporations, and incorporated entities that are filed with the state. So, especially your LLCs and corporations, heavily, there might be other entities that apply as well. But these specifically are really being targeted with the Corporate Transparency Act. And there's really no privacy for an LLC whatsoever. The only exception being is that if the LLC is owned by, let's say a foreign express trust or something else like that, then, the trust's ownership of the LLC might still have to be reported. However, what it does with the income and other things like that, or, any other, assets, because as a, once the business is owned, then the business's income becomes an asset to the trust, things like that. That's, again, not legal advice or financial advice. That's something that you kind of have to assess yourself. But there are, many different advantages for an express trust. The main one is asset preservation. So, with an express trust, the business name is naturally protected by injunction. It may also use a trade name or trademark for trust purposes without registration. Something good to note. And with a corporation, it must apply and secure fictitious firm name and must register all trade names and trademarks. With an express trust, all federal excise tax and state organization and franchise taxes are legally avoided, because it is not accountable to the state directly, it's accountable to its beneficiaries. Now, if it contracts with the state, that's a different story entirely. The opposite is the case for a corporation, except for state taxes in certain states. In either respect, all corporations are taxed indirectly via inflation. An express trust is not subject to foreign corporation laws of any state. It's not inherently subject to commercial regulation, except for income derived from corporate stock and physical franchises under Article 1, Subsection 8, Clauses 1 and 3. Express trust is a valid legal entity in all states of the Union. And a corporation is inherently subject to all foreign corporation laws and public policy regulation. And an express trust may function as an Article 4, Subsection 2, citizen of the United States via its trustee, not a 14th Amendment citizen. This citizen is understood in the constitutional law as the private citizen. And with a corporation, it is a 14th Amendment citizen, regardless of citizenship of corporate officer. Generally, state corporations require officers to be citizens as well. The citizen is inherently public due to the nature of the amendment. So these are some very, very key distinctions between, an incorporated entity like a corporation or an LLC and, something more along the lines of an express trust, as kind of put forth by Carlton Albert Weiss. And, this isn't the only form of express trust, but Carlton Weiss did a very, very good job detailing, why you should even use one in the first place. And this is an excellent model for an express irrevocable trust. It's not specifically denoted for business. Originally, it says in the handbook that these were originally known as Massachusetts land trusts. But, according to its nature, having ownership of, or, the rights of ownership to real property, personal property, and intangible property, it can carry on business. So that is something to be aware of as well. And there's so much flexibility, provided you understand trust law. Especially, if you're acting as a trustee for a private, trust organization like that, you really have to understand how trusts work, operate, and your duties and obligations, as well as your benefits and privileges that come along with it. So, knowledge of trusts and their operation is key to being able to move in trust and operating out of trust. Like I said, that is the biggest thing with it. There is a knowledge level that you have to be at to be able to, effectively operate and not breach your own trust. Because most people aren't aware of, what documents need to be public versus private. And there's more private documents than public. So, that is something to be aware of as well. That is one of the, I guess, what you can call like trade-offs. If you're not as well versed with it, you do need to study and understand what you're doing. But that being said, once you understand trust law, and it's not hard to understand, it's just we've been taught so much debtor creditor in this, growing up, and what we've been told in the public, that most of the time it's just a little bit difficult for people hearing it at first because it's so new. It's not really per se something new, it's just a paradigm that as kids we understand, but we've been taught differently. So this was a look into, a good model on the differentiation between, incorporated versus unincorporated. They both function as, if you will, private corporations. Essentially, they're accountable to either their shareholders or their, beneficiaries, the two being alike, and their board of directors or board of trustees. So some things to be aware of. If you need assistance in preparing the paperwork for an express trust, that is a service that I do provide. For my time, I don't really charge for anything but my time. I do ask for donations of $350 or more for an express trust, and I do set that up with a revocable living trust, a domestic living trust, an express trust that's foreign, and an indenture with it. So if you're interested in that, please let me know and fill out the contact form on my website. The link to my website will be listed in the description. If you'd like to join the Private Equity Weekly Workshop, where we discuss, these topics and various others, extinguishment of debt, especially dealing with other things like mortgages, credit card debts, bills, things like that, please consider joining. There is it's for donations of $200 or more, and you can, my PayPal, Cash App, and Venmo will be in the description as well, and that is for a lifetime membership. So that is there. We cover a lot of different things in the group, and it's a weekly Zoom call on Friday evenings at 7 p.m. Eastern for the members of the group. And the replays are available we have a Signal group, a Signal Messenger group as well, set up to be able to ask questions. That is something there also. And if you still, want to set up like maybe a one-on-one or a consultation with me, I do have those available. Just fill out my contact form on my website as well and mention that in there as well. I don't charge for the first 30 minutes. I need to, determine whether or not I'm able to assist you. Anything beyond that, I do charge $75 per hour, just like I said, again, for my time. So, be aware, for certain things. I have been working quite a lot. I've been very, very busy. I do have time to take in, more consultations and more trusts. that being said, but I do my best to make the most of the time that I spend with my clients and the members of the group. So I hope this was helpful in the differences of why you should set up an express trust. There are many different benefits to it, especially in dealing with privacy, asset protection, your choice of tax laws. You still have to play by the rules, but you do get to choose what rules you play by, because there's different rules and sets of rules. So you at least get a better choice in tax advantages and benefits that really do help, provided you understand tax law, things like that, which again, that's where due diligence comes in. But that this is something that may not be best for everyone, but realistically, most people need them, whether you understand it or not. Most people realistically need an express trust. There are the other ways to operate, mind you, but equity, I've found, is, especially exclusive equity, is by far one of the easiest ways to be self-accountable and govern yourself, lawfully and legally, to where you're able to manage your obligations effectively. So, express trust, you're able to choose the way that your company is structured. There's less reporting requirements. Any reporting requirements generally that you do have most of the time are directly to the beneficiaries of the entity itself. And those are the ones that really govern everything, because in equity, the beneficiary is regarded as the true owner. So especially if you're a trustee, you will have to account to your beneficiaries. Those beneficiaries will have the right to bring suit against you if you are involved in some type of breach of trust or breach of fiduciary duty. So like I said, that is something to be aware of. But the corporations, they do have their benefits, but like I said, they are very public. They come with a lot of responsibilities, especially statutory, and that's just something you have to weigh out the pros and cons of each. So I hope this gave you some insight. Let me know if you're interested and you would like to set up a trust or consultation, or the private equity weekly workshop on Fridays. I do have the exclusive equity live discussions on YouTube every Thursday at 7 p.m. Eastern. So tune in for those. Other than that, all praises, glory, power, and honor unto the Most High, the God of Abraham, Isaac, and Jacob. This is B with To Be Fruitful Training Group, and I'll see you on the next one. Thank you.